My name is Jim Sellers. I'm a plaintiff's trial attorney who practices in Oregon, Washington, and I'm going to try and answer some questions for you that I have clients ask me about damages for pain and suffering and loss of enjoyment of life. That is a gross misconception. Although there is some relationship between what you've lost out of pocket or economic damages and what you should be able to be entitled to recover for non-economic damages. There's not a clear line. I'll give you an example. If you hurt your back and you have to go to a chiropractor and you incur a $15,000 bill, what you're going to recover for non-economic damage is not automatically going to be 3 or 4 times that. As I contrast that to a situation where someone has lost the lower part of their leg in an accident and they come to see me, the cost of treating an involuntary amputation in an accident is generally quite a bit less than what the non-economic damages would be. So let's say, for instance, it costs $15,000 to $20,000 to treat a person who's lost a limb. They're very likely going to recover a great deal more than that in non-economic damages because of the effect that the loss of the limb has had on their life. And so this business of the non-economic damages being worth 3 to 4 times the cost of your treatment is just simply a misconception. So those are a few thoughts on this issue. I hope you find them interesting. If there's a case you want me to look into, feel free to call me and we can talk about these things. Except for that, it's been nice to talk to you this afternoon. Hi, this is Jim Sellers. I'm a trial attorney representing injured people in Washington and Oregon. I'd like to talk to you briefly about what's called the statute of limitations so that you have some appreciation for it in the event that you have a claim. The statute of limitations is a statute, it's a statutory time period actually, during which you must either settle a claim that you have or file a lawsuit. And if you fail to do either one of those two things within the period of limitations, your recovery on your claim is barred. In the state of Washington, generally, the statute of limitations is 3 years. So if you're injured, you have 3 years to either settle a claim or bring a lawsuit, or it's barred. There is an exception to that. It's called the discovery rule. And if you did not discover the injury that you had for one reason or another, or the cause of it, you learned of it only after the passage of time, the 3-year period does not begin to run until you learn of it. And if that becomes an issue, an attorney needs to look at the facts of your case and try and give you some guidance as to when the 3-year period actually begins to run and when it expires. In the state of Oregon, the general statute of limitations is 2 years. However, Oregon's kind of a landmine when it comes to statutes of limitation because it can be less than 2 years. As for instance, if you're a tenant and or a guest of a tenant, I should say, and you're injured on the premises rented by a landlord and it's a defective hazardous condition of which they should have protected you against or warned you about, that statute of limitations is only 1 year. The other thing that you have to be careful about in Oregon is if you're hurt by an employer or representative of the government, you often have to file a notice of claim before filing suit. And the notice of claim periods